So the question is, in chapter 7s or 13s for individuals, are appraisals always done by licensed appraiser, or are there broker's opinions or whatnot?
Why don't we have Dan start with the petition?
Yeah, I
Because
mean,
that's where the first issue is going to have. How is it disclosed in the debtor's bankruptcy petition, and what's the value put in? And then how is it treated by creditors?
Yeah, really, and this, I think, goes to Mike's scenario before. I mean, the first opportunity for an appraiser to be involved in the bankruptcy process is before the bankruptcy case is filed. When any petition is filed, there is a schedule which needs to be prepared, Schedule A and Schedule B, which lists the real estate and the personal property that the debtor owns. And the debtor has to put a value there, okay? For real estate, if it's a close call, okay, if the home is worth $400,000 and there's an $800,000 mortgage, the chances of a trustee administering that piece of real estate under that scenario is low. So that debtor may be able to get away with just getting a market analysis to provide to the trustee post-petition to show lack of equity to try and get the abandonment. In a situation, though, where you have a close call, let's say you have a property that's worth $500,000, the debtor thinks it's worth $500,000, and the lien, the mortgage debt is $500,000, I would counsel a debtor in that situation to go out and get an appraisal, because the goal of that debtor is to have the trustee abandon his interest in the property post-petition. And if I can provide a trustee with an appraisal, something credible, at the first meeting of creditors, it's more likely that a trustee will take that submission as opposed to a realtor's market analysis.
So the direct answer to your question is there's no requirement. It goes to weight. What is so it's, I look at it from, like Dan does, from a malpractice point of view. I don't want to take the chance that the person entering bankruptcy says it's worth 500 and the debt is 500, so I say you're okay. A trustee will not administer this property because there's nothing in it for unsecured creditors. So I say to that client, because I don't want them to be wrong, and I say, why don't you go out and get a current valuation of the property? Now, do I say you have to get from a licensed appraiser? I don't say that, but if you're thinking down the road like Dan is, so that you're ready for this trustee, who obviously we deal with day in, day out. The problem with that is, so because again, debtor's own opinion of value can be listened to by Judge Kaplan. Doesn't mean it has the weight. But the scary part about it is that when you get into these scenarios, these trustees do this day in and day out. They may have appraisers like you or people in the industry who they really don't care what the debtor is giving. They're having their own check on it. And as we all know, the ultimate determination of value is a willing buyer and a willing seller. The good thing is there's no money, as the judge said, in the system, so there's no buyers, so there's not a lot going on. So you can get away with a lot more closeness. In the old days, if anything was within 10%, now we haven't talked about exemptions and we need to address that. I'm sure we're gonna get to that.
Yeah.
The exemptions are critical. But if anything was within 10%, a trustee wouldn't go anywhere near it. Would not make sense to administer any process because there's a 6% broker's commission, closing expenses or whatnot. A trustee, so in Dan's hypothetical, if the mortgage was 500 and the value was 550, trustee's not wasting his or her time on that.
Well, because, and we'll get to the question. Let's talk about exemptions right now. We're dealing with real estate. In New Jersey, we operate under the federal exemption rules. States are given an opportunity under the bankruptcy code to opt out of the federal exemption scheme. You have states like Texas and Florida that have opted out. New York has opted out. And they provide their own exemptions for personal property and their own exemptions for real estate. I don't have them all off the top of my head. In Texas, it's for the most part unlimited, or there are limitations based on acreage and whether the property is in an urban area or outside a city. Florida had at one point unlimited. Even on those unlimited, there's a cap now that Congress has put in, a six-figure cap. Here in New Jersey, we operate under the federal exemption schemes, which affords each debtor the ability to exempt out about $20,200 of equity. So if a husband and wife own a residence, between them, they have $40,400 of exemptions. So that money would get paid first. So when that trustee is looking at that property, he's taking the value, whichever value is there, subtracting out the liens, because mortgage liens get paid before exemptions. An exemption is the debtor's ability to keep money after payment of valid liens on the property. Exemptions don't come before the liens.
So you understand, going back to Dan's example, that just took the valuation to 600,000. Okay, so if the property in Dan's hypothetical is worth 600, the lien is 500. The mortgages, as the judge said, get paid first, and now the exemptions are 40,400 for a couple who file. The bottom line is, in order for a trustee, one of the colleagues of Dan, to want to administer or try to sell that property by using a broker, the valuation will have to come in at about 600 grand, or else they're not going to waste
That's a break even. 'Cause
Right.
If I'm selling a
Right.
property for 600,000 that has a $500,000 mortgage, and I have a $40,000 exemption, I've got to kick back to the debtors off the top.
Right.
I then can only pay my broker and my cost of sale. So I'm not gonna walk away with anything from that sale for my unsecured creditors. And that's who I'm supposed to be serving as a seven trustee.
Yeah.
Dave, can you just hold it? Dave's, the gentleman in the back in the
Yeah.
red shirt was waving his hand. Why don't we give him a shot? Because Dave is, just because he's been asking.
What should be the date of the appraisal? Because I've heard something different.
Great question. So,
When that appraisal is contested, should not the second appraiser be forced to use that same effective date?
okay, so you got to get that on tape. That's a great question. What's your name, sir?
Ken,
Ken.
what should be the effective date of the appraisal, the first appraisal done for the debtor, and when it's contested by a bank, should not that appraiser be forced to use that same date? Or should the specific date be set by the judge?
For seasoned bankruptcy appraisers, that is the first question that you're asked as a trustees counsel or as a debtors counsel. And I suspect as a lender's counsel as well. The answer is, it depends, and you should take your direction from whoever is retaining you. There is, not surprisingly, on this issue, you can find cases that are all over the lot. There are a number of cases.
Three main schools of thought,
Yeah.
three options.
Yep.
The date on the petition is filed, the date of the hearing, or the date of the confirmation of a plan, if it's a Chapter 11 or Chapter 13. And as Dan is about to say, until I butted in, there's cases out there that support each date. And what's wonderful about bankruptcy court is that you can get a bankruptcy opinion to say anything you want. There's a bankruptcy opinion out there on both sides of every issue. The 350 bankruptcy judges in the country are busy writing opinions, and we don't always agree. In fact, you're going to find that there's a bankruptcy decision very often by the same bankruptcy judge on both sides of the issue. There isn't always a consistency, and you might have to look to the next level, the district court that hears appeals from bankruptcy courts, or the Court of Appeals at the highest level.